What could you do if your disability case is assigned to a low approval judge? I'm Jonathan Ginsberg. I'm a Social Security disability attorney. And one of the things that can be really frustrating in a disability case is if you are assigned to a judge who approves only a small percentage of cases. Right now, nationally, the average is around 43–44% approval at hearings. But some judges approve at a much lower rate than that. There's one judge I know whose approval rate's at 17%. I had a hearing this week with a judge whose approval rate is 20%. So again, it's unfair in that if you are assigned a low approval judge, your chances of winning are low, but the judge next door approves 63%, and you probably would have won with the same facts. This is one of the unfair things, the inefficiencies of Social Security disability, but unfortunately we don't have a lot of choice as far as who they assign to judges. So what do you do if you're assigned to a low approval judge? Well, there are a couple of thoughts I have. First of all, don't assume you're not going to win. I had a case this week with a judge who's a 20% approval judge. I had a depression case and I won because the case was really strong and I had all the evidence and I had everything lined up the way I needed it. The judge is going to approve the case. So just because the judge approves a low percentage doesn't mean that he or she is not going to approve you. The second thing is don't go in with a bad attitude. There are obviously websites out there where you can look to see the approval rate, and if you see that your judge has a low approval rate, it would be tempting to go in there with a bad attitude, like, you're not going to approve me anyway, so to hell with you, I'm going to go ahead and just say whatever. You don't want to do that because, again, you don't know what's going on. You don't know if that judge maybe has changed his or her philosophy and may start to approve more cases. We just don't know. So I think you always go with the idea we're going to try to prove our case as best we can. If your judge is, if we're still in the pandemic when you're seeing this, and right now we're in the middle of the coronavirus pandemic, when we go to these hearings that are being done by phone, one of the things the judges will say is, do you agree to have a telephone hearing? If you and your attorney say, you know, this judge is not going to give me a fair shot, you can say no. I want an in-person hearing, and of course that may delay your case 6 or 8 months, but you would not have that same judge. So that is another possibility. Third thing would be if you were to move. And again, I don't tell somebody to move because you got a bad judge, but in theory, if you moved 50 or 60 miles away to the jurisdiction of a different hearing office, you can ask that your case be assigned to a hearing office closer to you, and you would not necessarily have that judge either. So those are some things you can do to get to a different judge. Otherwise, what I would tell you is you want to just approach the case the way you normally would. Put more focus into objective evidence, because judges with low approval rates, excuse me, typically deny because the evidence is not compelling. So if at all possible, if your case is one where you can have an MRI or a CT scan, make sure you have a recent MRI or a CT scan. If you have a treating doctor who will fill out a functional capacity form, get that. That can make a big difference for different judges, regardless of who the judge is, but that can make a real difference, having a strong functional capacity form. If the record is not really, really strong, talk to your lawyer about getting an independent medical examination with a doctor of your choosing. Again, doesn't mean you're going to win, but it means the evidence is strong there, so at least it gives the judge something to think about, because even though the rules are such that a judge can rely on any doctor he or she wants to, if you have support from a treating doctor, I still think that would be something that would make any judge think. Secondly, if you have independent medical examination along with treating doctors, 3 or 4 doctors saying the same thing, and one non-examining doctor saying something else, I think you could make an argument that that non-examining doctor should be given less weight. When you practice your testimony with your lawyer, make sure that you are coming across, and practice with your lawyer, that you come across as being believable and credible. Don't say, everything hurts, my pain is at a 10 all the time. That is not believable. Talk about and think about how to describe your level of pain, that 3 or 4 hours a day my pain will go to an 8 or a 9 and I have to lie down. But sometimes, maybe 2 days a week, my pain's at a 3 or 4. That will make you more believable. If there's a medical problem that you had that is no longer bothering you, tell the judge at the outset. I remember I had a case with a judge with a traditional low approval rate. My client had about 5 things when we applied for benefits, but by the time the hearing rolled around, one of those issues, I think it was a left shoulder problem, had resolved. And so my client tested, the judge says, "What about your left shoulder?" And he said, "You know, Judge, that's better now. I don't want you to consider that because my shoulder is fine. I don't have any limitations." You could sort of see the judge step back and say, wow, this is a person who's actually saying that he's got a medical problem that's resolved. He's believable. And sure enough, the judge's attitude totally changed and the case was approved. So little things like that can make a big difference. I think some judges just inherently think everybody's out to try to squeeze the system for as much money as they can. If you go in there and say, you know, something's gotten better, this body part is not bothering me anymore, then it can really make a difference with the judge. So those are just some ideas. I think this is one of these things where you want to talk to your lawyer about it. Again, some lawyers have better experience with certain judges than others. And like I said, I never go into a hearing with the idea that the judge is going to deny my client's case. I'm putting on the strongest possible case, making the strongest possible argument. I've even gone into cases. I remember I had a case years ago with a judge with a very low approval rate, and I had a client that I really believed in. And so I said, you know, I went in there in my opening statement, I said, "Judge, you know, I've seen a lot of cases involving," I think it was, maybe it was diabetes. I don't remember exactly what it was. "I've seen a lot of diabetes cases, and I've done this for, at the time, 20 years, 15 years. This one really stood out to me, and here's why." And so you could sort of see the judge stepping back and paying a little more attention. Again, I had some built-in credibility because I've been appearing before that judge many times, but I basically said, you know, this case is different, and here's why. And that helped me get an approval in a case that I think it was a strong case, but with a judge who, you know, normally wouldn't approve that type of case. The fact that I went in there and said, you know, I'm putting my reputation on the line to say this case should be approved. This is a legitimate case. So there's some ways to approach it. Those are just some ideas, that things that I've done that I find actually have worked for me. So again, don't assume because your judge has a low approval rate that you're going to lose. But again, you have to think about it and come up with an argument, a theory of disability, an approach that will address that particular judge's issues. And again, if you know that your judge is really focused on objective evidence, you want to provide that. I keep a little off topic here, but I keep a database of every judge that I appear in front of. And after the hearing, I make note, what did the judge like? What did the judge not like? Does the judge want an opening statement? Did the judge really focus on this? One judge, for example, that I appear in front of frequently spends a lot of time on past work, and yet her hearings are 45 minutes. Well, she'll spend 20 minutes of that talking about past work. Well, I know that, so now when I have a hearing with this judge, I will do a pre-hearing brief where I identify in a chart format all my clients' past work, so we don't waste time with that, and we spend more time talking about the actual issues in the case. So that's the sort of thing that you have to keep in mind to make judges feel comfortable that you respect their time, so that you can give your chance, as an attorney, I give my client the best chance of winning, but as the claimant, you want to make sure that your testimony is geared toward that particular judge, and your chances, I think, will improve even with a low approval judge. Hope you found this useful. Please give it a thumbs up on YouTube or Facebook if you did. Visit my website at ssdanswers.com. I've got a free Secrets to Winning Disability Survival Kit there, and I've also got a case evaluation form. And of course, if you do find these videos useful, subscribe to my channels and like our Facebook page. Jonathan Ginsberg here, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.